Hi, this is Kelly Glick. This is my presentation on tort liability. Let's get started with a definition of what tort liability is. So there are two types, intentional and unintentional, which can also be called negligent tort. Under intentional tort, what we're talking about is intentional injury to another individual. So that could be assault, which also includes even meaning to cause harm, even if the harm isn't carried out. And then battery, false imprisonment, and defamation, which also includes libel, which means defamation in writing. And then negligent tort or unintentional tort is there's four parts that must be proven. One is that the person who's being accused actually has duty to care for the injured party, and then you must prove that there's a breach of that duty to care for the individual. And then there must be a link between the actual actions of the person accused and the person who was injured, and then there must be injury involved in order to prove negligent tort. These categories can also include injury to property, and also which could include trespass charges, and then it includes emotional injury that someone might incur as well. So let's look at some cases. The first case I chose is Mitchell versus the Cedar Rapids Community School District. And this was heard by the Iowa Supreme Court in 2013, or it was ruled on in 2013. In this case, a student with a fairly low IQ and part of the IEP process and program of the school left school early with another student and was then raped by that student. The school was sued by the parent, who said that their negligence in allowing the student to leave school grounds led to her getting injured at a later time. So the questions that came up that were reviewed by the court include whether or not schools are responsible for students after they leave school property, so off campus or not during school times, and generally the courts rule for the schools in those situations. However, there was a whole series of events that happened before the student left campus that the school personnel could have potentially stopped the student from leaving or notified parents that the student was missing from class, and that could have prevented the rape that occurred after this. And so in this case, the courts actually found for the parents because they found that the school's neglect led to later injury. So the next case is Barnett versus Caldwell, and this was heard by the Georgia Supreme Court in 2018. And this involved a teacher leaving the classroom to use the restroom for a few moments at the end of the day, and two students were horseplaying, and in a very sort of random tragic event, the one student sustained a brain injury that led to his death. And so in this case, the parents sued the teacher, obviously, for not supervising, and that the lack of supervision leading to their child's death. And this was a high school student. The courts ended up ruling that the teacher had immunity because under the law, if a teacher is performing a discretionary act that is part of their school duties, that may keep them from fulfilling their otherwise supervision duties that are assigned to teachers. And so in this case, the teacher was found to have immunity, and the courts found in favor of the schools. So in our third case, Doe versus Tippecanoe School Corporation, this was ruled on by an Indiana federal court in 2017. In this case, a teacher was found to be having a sexual relationship with a student, and when that was found out, the teacher was arrested. However, there were numerous reports of concern prior to this time, and the parents sued the school district, saying that the school did not react fast enough, that they did not take steps to discontinue this relationship or pursue charges against the teacher early enough. And in this case, the courts actually ruled for the schools, and they said the school would have been liable if they had had information that a sexual relationship was going on and didn't act. But in this case, it was pretty clear that the school did not know there was a sexual relationship. They knew there were suspicions and had taken some steps to look at that, but had not fully found anything out that would have warranted further action. So in our fourth case, in Peterson versus Baker, this was heard by the United States Court of Appeals in the 11th Circuit in 2007. This occurred when a student was acting out and tried to leave the classroom, and there was an altercation between basically the teacher and the student did something physical first to the teacher, and then the teacher was physical back. And the teacher was sued by the parents for injuring the student. And the court in this case found for the teacher and said that basically the teacher's actions, even though they were physical with the student, fell under corporal punishment, and also the teacher had no intention of hurting the student, was just trying to get control over the situation. And so since the teacher didn't have any malice intent, then that, or malicious intent, then therefore her actions were perhaps justified. So let's go on to number 5. So this case was heard by the Alaska Superior Court and ruled on in 2014. And in this case, a very tragic incident occurred where a kindergarten was rushing to meet his mom after school and was very excited. And there were some exposed stumps from bushes that had been cut down. And the student fell on the branches, and a little spike actually pierced his eye and brain, leaving long-term brain injury. And so in this case, the school was sued because of having exposed branches and not necessarily putting any barriers around it to protect students. And so in that case, the school was actually found to be negligent, and the parents were awarded $4.5 million in medical costs and an additional $180,000 for pain and suffering. And so that was a rather large award. And again, the school was under responsibility, had the responsibility of protecting kids from what they knew was a hazard on school property. So let's go back through these cases and talk about what could have prevented these. So when we go back to Mitchell versus Cedar Rapids, in this case, I'm not sure that my district would have acted any differently. We have an open campus, and so all students are allowed to come and go as they please. And we still take attendance, but oftentimes attendance calls don't go home until the evening, just like in this school district. And so I think that when we're talking about kids with IEPs and lower IQs, we do have very connected case managers who do communicate with parents when kids are missing. And so I could see this going either way. I could see our case managers catching it or not, just like in this case, and letting parents know ahead of time or at the time that the student was missing early from school. I think prevention-wise, one of the things you could do is definitely provide additional training for staff. Just making sure that teachers know they could potentially be liable if they're not communicating regularly with parents, especially with kids who have limited decision-making abilities, including even high schoolers. But again, the IQ piece comes into play in this one. So going on to Barnett versus Caldwell, in this case, I think this sort of situation probably happens frequently in our classrooms. Hopefully kids aren't automatically getting up and engaging in horseplay the minute the teacher's not there, but we do have 90-minute classes. And so there are many moments where teachers have to run and collect something or use the restroom. And so I can absolutely see this situation happening. Again, just a really random injury that ended up leading to death. And so in this case, I think again, reviewing with teachers their responsibility to supervise their classes. I think this is a really tough one to prevent, because if a teacher grabs another teacher and asks them to supervise, then that teacher's not supervising their class. And so especially with how our school is laid out, I can't imagine, unless there was a student teacher perhaps available, but I'm not sure that would completely prevent this incident either, and how the courts would rule on a student. What would happen if there was an injury that occurred when a student teacher was left in charge. So let's go to this case. So in this case, I do believe that there's some more prevention that could have happened in this case. Again, I think this is a situation that happens in schools. Unfortunately, it's not completely uncommon, where lots of people have suspicions, but nobody has kind of all the pieces put together on a situation. And so I'm not sure. I'd be really curious if courts in other states would rule in the same way. I could see courts ruling for for the plaintiffs in this case, saying that the principal didn't collect enough information when there was suspicion. In our district, obviously, if there's any suspicion at all, an administrator is supposed to be notified right away, and they're supposed to work with human resources in trying to figure out what to do with the case, even if there's a suspicion, although I know that doesn't happen on every occasion. And I think what principals need to realize, I think they need training as far as sexual assault goes, because often the people who are suspected and end up being sexual perpetrators are some of the favorite teachers in the school because of all the special attention and how well they get along with kids. And the special attention that they give to them. So there's a lot of misunderstandings about who can be a sexual perpetrator and who cannot. And so I think getting rid of those myths and training administrators, and then also empowering them to really collect lots of pieces of information to try and put that puzzle together would be very important. So let's look at our fourth case. So in this case, I really feel like in our district that the teacher would have given the concerns about her conduct, and while the court case was going on, she would have been placed on leave. Whether that would have been paid or unpaid, I don't know. I'm guessing unpaid, but I'm not positive about that. And I do believe that our district does a pretty good job of training people about whether you're allowed to lay hands on kids or not. CPI is a training that new teachers and all special ed teachers have to go through so many years, and it's about de-escalating situations, and if you do have to lay hands on students, how to do that and how to fill out the appropriate reports. And then all teachers have to do a mandated online review training of those same topics every year. And so I do believe that we do a lot to kind of remind teachers that that kind of altercation wouldn't be appropriate in our district. But other than that, I'm not sure what else you can do for prevention, and I don't know if the school district had that in place or not. And finally, for this tragic incident in Alaska, I think that our facilities department is pretty good in our district about blocking off areas or responding pretty quickly to anything that's a safety concern, but definitely reminding teachers that anything that's on the playground or on school property or in the building that could be a hazard to kids must be reported. I think reminding them of that, since they're really the eyes of the school as they're taking their kids to different places inside and outside, would be really important. And so that's what I would consider being important prevention in this case. So in conclusion, I just added our PSD policy on staff conduct and responsibilities. One of the things I noticed is we don't have necessarily specific responsibilities laid out in our district policies about some of these tort cases that came up. But in general, PSD, Poudre School District, requires that all staff members need to have a familiarity with all kinds of work-related state and federal laws, our board policies, and then we need to use them. And that this last line I like, as a conclusion, staff members shall be expected to carry out their assigned responsibilities with conscientious concern. So again, I don't think that tort cases or tragic accidents can be avoided in all cases. At the same time, the more ethical we are and the more we follow protocol and the more that we look around us and see what's around us and are concerned with kids and their safety, I think the better off we are in avoiding these situations. Thanks so much.